All right. I wanted to shift from miscarriage to loss. And this miscarriage is more a term of art. But it's not clear to me why a claim arising out of the loss of property cannot include a loss that results from intentional conduct. That's just not the way the term is normally used. A claim arising out of a loss does not have to involve property that has been lost in the sense that it can't be found. It just means that there's been a deprivation in the value of the property, right? I can submit, suppose vandals set my car on fire and I submit a claim to my insurance company. That is a claim arising out of the loss of my car. Even though I know where my car is, it's in front of my house, but it's a burned out Hulk, right?
Yes, Your Honor, but we would never say, and this is Justice Kagan's point, that the vandals lost your car, right? And that's the way that the sort of whole statute is structured.
It doesn't. It says it doesn't talk about what somebody has done. It talks about the consequences of something, which is any claim arising out of the loss.
So I think that this is sort of consistent throughout the statute. It's not just that you have to prove an assault happened in the abstract. You have to prove the government assaulted you, right? And so here it's the government lost your mail. Now, even if you don't agree with me on that, I think if you agree with me on miscarriage, that resolves the question. So that is, even if in some settings loss covers wrongful conduct, I don't think we have any story for why Congress would say wrongful conduct not counted under miscarriage, wrongful conduct not counted under negligent transmission.
Well, that's your surplusage argument, and the surplusage canon is of value, but it's not the way Congress always writes statutes. It's not the way people always talk. So it's valuable, but it's worth only so much. But I'm really troubled by how you extract from, how you read into the phrase, any claim arising out of a loss to exclude intentional conduct.
So just to clarify, I just want to make clear, that's not actually our superfluity argument. What I'm saying is, if you accept our miscarriage mens rea argument, then I think you've got, you either have to accept that loss is limited to negligent conduct, or you've got a situation where, okay, postal worker takes a hammer to a package. Scenario 1, he just breaks off the handle of the mug. Scenario 2, he totally shatters the mug. Scenario 1, the government says that's not a loss. He just broke off the handle of the mug. And so it's one of the other two terms, so wrongful conduct, and so therefore it's not immunized.
Well,
right?
It's a different question about whether the loss of the mail means the loss of all value of the mail or a diminution in the value.
That's right, but Congress could not have wanted liability to turn on that fine distinction. And if you say loss, but only loss covers wrongful conduct, right? Miscarriage, negligent transmission exclude wrongful conduct. Then at that point what you're saying is Congress wanted liability to turn in a case involving wrongful conduct on this kind of fine distinction between destruction, loss, wrongful conduct covered, and diminution, not loss, wrongful conduct not covered.
Assume,
Go ahead.
If miscarriage does cover wrongful conduct, so let's assume that, which is contrary to what you've been assuming, but assume miscarriage covers intentional wrongful conduct, then your arguments are?
So assuming, again, contrary mountain of evidence.
I'm reserving
evidence.
it. You're not conceding anything. You're not conceding anything. Yeah.
Then I think our fallback position is that you have to think about, we basically argue Dolan, right? Dolan says loss is destroyed or potentially misplaced. Miscarriage is delivery to the wrong address. We are neither of those two. So we're some kind of transmission error. At common law, this would be called a willful refusal to transmit or a wrongful transmission. We give you case sites for that. Congress conspicuously doesn't include willful refusal to transmit in this list. It's only negligent transmission. So I think we still win, but I think if you decide for us that miscarriage only is limited to negligent conduct, you don't have to get into the kind of fine distinctions between the three terms. If I may make one other point about the kind of structure of the FTCA. So the FTCA's exemptions are divided into kind of two categories. Some are very broad, right? Any activities of the Tennessee Valley Authority, fiscal operations of the Treasury, that sort of thing. The others list specific actions, often with a mens rea, right? So 2680A, executing a statute with due care, 2680H, battery but not negligent touching. This one, 2680B, as Dolan said, is clearly in the latter mold, right? It's not saying any activities of USPS, any failings in the postal obligation, any mail handling activities. It's not doing that. It's listing 3 specific terms pegged to a mens rea, the way the other provisions do throughout the FTCA.
Can I ask you